one of the things I wanted to remind all of us as a management council is that when we, as administrators, participate in the interview committee process for screening, interviewing, and selecting staff, you know our processes, they typically involve a small committee or multiple committees. They also, hold on for just a second. They also require sometimes a faculty member and a manager co-chair, or a classified employee and an administrative co-chair. When we are playing that role, we are the Equal Employment Opportunity Officer. Remember that switch we made? That we no longer have the EEO committee with a group of faculty, and we tried to run around and find one of those faculty members to sit in on an interview, and we had trouble getting them people available and so on. So we assumed the responsibility for being that Equal Employment Opportunity representative. So today's training is about getting us grounded again in what those key elements are and knowing what our responsibilities would be to intervene or guide or monitor an interview process and or procedures to make sure that we're doing that correctly. Does that make sense? So that's what we're going to spend the last half of our management council meeting on today. And from our law firm here helping us with that today, let's give a warm COS welcome to Pete Deno.
Hey, good morning, folks. So as the title of the slide says, this is an Equal Employment Opportunity Law general overview. In the approximately 1 hour of time that we're going to have available this morning to talk about these issues, we can really cover broad topics, surface level stuff, which is our goal here today. Understand that there's a lot more depth behind every single one of the issues that we're going to touch on here today. You've got written copy of the PowerPoint materials distributed. Hopefully everyone was able to receive one. That will give you your springboards for any time you do encounter an actual issue in the real world. You'll know where to start looking for answers, okay? We're not going to have all the answers to every possible scenario you may encounter, but we will help you to do issue spotting, as I like to call it, where you have the understanding and the ability to recognize a problem, hopefully before it festers and becomes an intractable problem, and so that you can go out and seek a solution in a proactive fashion, okay? So that's kind of the goal here today, is general overview, cover some basics. A few things I'll kind of skip through, but as I said, you have a copy of the slides so you can study those if we don't have time to cover it here. And I'm happy to answer questions as we go along as well, okay? So let's get started. Okay, we're going to cover state and federal law, equal protection rights, non-discrimination, non-harassment requirements in general. Okay, so what are we talking about? When we look at federal law, we've got a variety of laws, including Title VI, Title VII of the Federal Civil Rights Act, Title IX, and a few other laws that basically protect both job applicants. This is important, as Dan mentioned, and I'll emphasize this throughout. These laws not only protect current employees in the course and scope of their employment with respect to working conditions, hiring, firing, promotion, demotion decisions, which they certainly do. Don't be misled. They absolutely govern those aspects of the employment relationship. And in fact, that's probably where the vast majority of problems arise and where most litigation occurs. And so the body of case law that has developed around these legal provisions generally revolves around what happens after somebody is employed. Oftentimes that leads people to overlook and sometimes be ignorant of the fact that both state and federal equal employment opportunity laws absolutely apply at every phase of the employment process, all the way to recruitment materials, advertisements, job postings, okay? The actual interview process, screenings, hiring decisions, all the way to actual employment. So this covers the entire spectrum of the employment process. I want to make that really clear, and I think that underscores what Stan was setting out for you. So what does federal law generally protect? Job applicants and employees from unlawful employment practices based on what are called protected characteristics under the law, okay? And state and federal law define different categories that are considered legally protected characteristics, which employers cannot use as the basis to make a decision about somebody that operates to their detriment. In other words, you cannot discriminate against a person or a group in the employment context based on one or more of these protected characteristics. The law likewise prevents employers from either engaging in as supervisors or permitting coworkers or even third parties in some cases to engage in conduct that would constitute harassment, either a quid pro quo or a hostile work environment type based on the same protected characteristics. Federal law covers a narrower set of protected characteristics, okay? You see some of those listed here. Many of them are commonly known: race, color, religion, sex, including pregnancy, national origin, age, disability, genetic information. Specifically, those laws, as I mentioned, protect people against disparate treatment discrimination. That means intentionally treating one person or group worse than another on the basis of one of those protected characteristics, okay? Disparate impact. What does that mean? How is that different from disparate treatment discrimination? That basically means there is what's called a facially neutral policy or rule, okay? The rule by itself doesn't discriminate on any of those protected categories, but the impact of its implementation or its application has a disproportionately negative effect on one of the protected groups or a person belonging to one of those groups. That's what disparate impact means. It's different. It's not the employer deliberately or intentionally discriminating against someone because of one of those characteristics. In other words, having what's called racial animus, or animus against disabled persons or any of the other protected classes. There is no such intent. There is no animus. But the way the policy is applied, even if it's neutral, it has a disproportionately negative impact on persons or groups in those protected categories, okay? Harassment, I already kind of give you a preview, and we'll cover that in more depth. Retaliation, what is that? We'll cover that in depth, but to give you a preview, retaliation is taking adverse employment action, as the law defines it, which we'll cover, based on somebody exercising rights in connection with, let's say, filing a complaint of discrimination or harassment, cooperating with the employer's investigation of a complaint as a witness, or even advocating for themselves with respect to their rights. Let's say somebody requesting a disability accommodation can actually result in a retaliation claim if the employer takes adverse action based on that request for accommodation. So these are things that the law covers. Finally, failure to provide reasonable accommodations, and that legal standard applies both with respect to disability and with respect to religion, although the standards are different, and we'll hit that too. And as I mentioned, the final bullet point, just to reemphasize, this covers all phases of the employment process, not just post-offer, post-employment, actually in the office working, okay? So what about state law? What I've done here is I've highlighted just a handful of additional categories that California state law protects in the employment context that federal law, by the letter of it, doesn't protect. So just familiarize yourself with these if you weren't already aware. California law, which is probably not surprising to any of you, it's certainly not to me. California law is more broadly protective of employee rights in the workplace than federal law. California is usually out in front of these kinds of things. That's certainly the case with respect to the Fair Employment and Housing Act, which is our state non-discrimination, non-harassment, and employment law. So the additional categories, just to cover them: sexual orientation, marital status, medical condition, gender identity or gender expression, and military and veteran status. Those are all expressly defined in the Fair Employment and Housing Act as unlawful grounds to discriminate or harass against employees in California. One thing I'll mention briefly, although the federal law does not specifically include sexual orientation, gender identity, or gender expression, federal law under Title VII of the Civil Rights Act does prohibit discrimination on the basis of sex in employment? Well, the EEOC, that's the Equal Employment Opportunity Commission, the federal agency that enforces and in fact prosecutes legal cases for violation of federal discrimination laws, they have taken a very aggressive posture, and they've decided as an agency, they are now going to aggressively and vigorously prosecute sexual orientation discrimination cases on the theory that the term sex in Title VII statute implicitly includes sexual orientation as well. So that issue is still being played out in the courts, but the bottom line is we're already required to follow that in California anyway. For our purposes, it's moot. But it's just interesting to note that the legal landscape is clearly moving very progressively and aggressively in the direction of expanding protection for employees against discrimination, harassment in the workplace. So you can bet as EEOC moves federal law forward, California is probably going to continue to move itself ahead of that as well. That's just kind of pay attention and anticipate that California will continue to expand its legal protections for workers. Okay. All right. So I've already sort of alluded to the California anti-discrimination harassment law is the Fair Employment and Housing Act. And this is basically an all-encompassing non-discrimination equal employment opportunity statute that sort of cobbles together the various pieces of federal law, and as I mentioned in the previous slide, actually augments those federal protections and adds different categories to make sure California workers are even more protected in the workplace against discrimination and harassment. And the EEOC I've already covered is just a federal agency that enforces federal law in this area as well. Okay, situations that are covered, we've kind of walked through this as well, so I won't dwell too much on it. But again, the full gamut of employment activity all the way to advertisements for openings, recruitment, hiring, and then all the decisions that employers make once somebody is actually employed, including promotions, demotions, termination, etc. As I mentioned, in terms of retaliation claims, you've got activities such as filing a formal complaint of discrimination, participating in an investigation even as a witness, and workplace harassment is also covered by these laws as well. Okay. So I mentioned the disparate treatment and disparate impact dichotomy in terms of a discrimination case. This just gives you a kind of quick summary of how courts actually look at these cases if there is a situation that cannot be resolved at the local employer level, okay? If somebody files a claim either with the Department of Fair Employment and Housing or EEOC or even goes to court to litigate a claim of employment discrimination, this is basically what you get. It's called the McDonnell-Douglas burden shifting analysis, which is a long-winded way of saying the person who files the complaint has to meet an initial burden of showing that there may have been some discrimination, okay? And I won't go through the whole thing, but this is basically the legal standard where an agency or court would evaluate, have they made what's called a prima facie case? In other words, is there something there that we ought to look more deeply into? If they meet that burden, which is kind of a low threshold, then you shift. It's called burden shifting analysis. It now shifts to the employer. The ball is in the employer's court. And this is where I want to take a step back. If you get in this situation with an employment discrimination complaint, and particularly if you call us or another lawyer to try to help defend against it, when the burden shifts to the employer, and it almost certainly will because, as I said, it's a low threshold to actually meet the burden of a prima facie case. This is where it becomes absolutely imperative and critical that the employer and your lawyers will try to extract everything they can out of you in this regard. You have to be able to prove. You now bear the burden because, remember, it's shifted to you as the employer. The employer now has the burden of proving that we had a legitimate non-discriminatory reason for whatever action is being challenged as discriminatory, okay? How do we meet that burden? How do we prove it? That's where your lawyer is going to come in and say, I need you to show me all the documentation that supports the decision you made, whether it's based on substandard performance. I'm going to need to see evaluations, observations. I need the documentation. Let's say it's based on a misconduct situation. I'm going to need to see the documentation that shows a full and fair investigation. I need to see the findings of fact and the conclusion. I need to see that we followed the process correctly, and that the outcome was warranted and fair. We're going to need to see all that paperwork, and I know you guys go through other workshops to learn about documentation, file building, dotting the I's and crossing the T's. This is a situation in the context of discrimination claims where it is absolutely critical that you follow those processes that you've otherwise been trained to do. Because if we can't prove that we had a non-discriminatory reason that was actually justified by some business need, then we could be in really hot water. Let's say we do dot our I's and cross our T's. We need our burden to show, no, we didn't fire that employee because he's black. We fired that employee because he was a poor performer. We fired that employee because he punched a student, something like that. Now the burden shifts back to the person who made the discrimination claim. They are then going to have a much higher threshold to prove, I understand what the employee said, I see their evidence, but I think they're lying. I think it's a pretext for a discriminatory motive. That burden is really difficult to prove. That's why, again, when we get our opportunity at that second phase to show our legitimate non-discriminatory reason, it is absolutely essential that we're able to do that successfully with solid, robust evidence. That's going to give us our best chance of defending ourselves successfully against any of these types of claims. Because I'll be honest with you, there are certainly cases where an employee or even a job applicant has genuinely been treated unfairly and in fact unlawfully based on one or more of those protected characteristics that we've walked through. Those things do happen, and when they do, unfortunately, it costs employers an awful lot of money. A lot of these cases go into the 7 figures as opposed to the 6 figures, particularly sexual harassment cases, okay? But in a lot of situations, what you have is an employer who did everything by the book correctly, and they made a decision that was obviously unfavorable to the employer applicant. They are disgruntled and perhaps not particularly realistic about the reasons why they weren't successful or why an adverse action was taken. They decide there has to be another reason. What could it be? I know. It's because I'm over 40 years old and protected by age discrimination law. It's because I'm a woman and they prefer to hire men. It's for any of these reasons. They get it in their mind. Or perhaps some advocate or union representative tells them, you need to file a discrimination complaint. I don't think they treat you fairly. And all it takes is that seed in their mind, and they engage the DFPH process, the EEOC process, the courts. And even if we know there's no legal merit to it, it's really easy for them to put the burden on us. So just, I know I'm taking a bit of time on this, but I think it's a really important point. If you remember nothing else out of what I said here this morning, please do remember how valuable I think that type of documentation and preparation is. A lot of times when lawyers come in and talk to folks, we say, in these kind of situations where you anticipate that it is probably going to result in some kind of acrimonious separation with an employee, for example, try to be thinking a little bit like a lawyer. And how would a lawyer analyze the situation? And what would a lawyer want to have available to defend our decision-making process and our actions, okay? It's not your job to be a lawyer, but I think it can and should be a part of your job to try to think like one in situations like this, if that makes sense, okay? All right.
Question.
Oh, yeah, go ahead.
So in that case, in that example, if it's an applicant for a job, that it's not an internal person, we don't know.
Right.
What's the evidence that you need to show? that it
So
was-
I've had DFPH cases specifically addressing alleged discrimination in the hiring process, for example. I haven't yet encountered one that said the application itself was discriminatory, although those cases do exist. For example, they may ask for certain information that we ought not to ask for, such as specific information about someone's disability status, things like that, which we cannot ask at that initial stage because it tends to operate, or at least it creates the perception that it operates to screen out people based on an unlawful category. Whether or not we're actually doing that isn't necessarily the point. If it has the effect of dissuading people from even seeking those positions because they have a disability, for example, that's probably going to be considered discriminatory. Again, it's not just intent, disparate treatment, right? It's also a disparate impact risk. If we have a neutral policy, we don't mean to discriminate, but the way it is applied in practice has the effect of discriminating against people, we could be in trouble for that. So those cases do happen. What I see more often is an unsuccessful job applicant, and they decide, I'm clearly the most qualified for this position. The only reason I didn't get the job was because I'm XYZ, one of these categories, right? We get a DFEH complaint. So, and they say, I want to see all of the recruitment paperwork, I want to see the application paperwork, I want to see your policies with respect to hiring, and I also want to see information that you gathered about all the other applicants, about their qualifications, and in particular, I want to see who got hired and how do they compare to this person, both with respect to protected classification status, with respect to qualifications, and then they'll decide, did we make a fair, neutral decision that didn't discriminate based on any protected legal categories, or conversely, did we screen somebody out because we preferred somebody who wasn't disabled, who wasn't black, who wasn't a woman, etc. Those cases get filed rather frequently, but I find that most often they lack merit. And so again, it's simply a matter of us being able to submit the appropriate documentation that verifies our decision-making process was completely devoid of any consideration of the alleged discriminatory category. For example, I've had one recently with DFEH where an unsuccessful job applicant who was over 4 years old, therefore legally protected by the age discrimination law, said, I didn't get the job because I'm over 40. In fact, I think he was over 60. And he found out through a little bird that they hired someone who was about 23 years old. So clearly this is a case of age discrimination. Okay? Is it enough to pass that initial screening stage of DFEH, the prima facie case? Yeah, absolutely. That was more than enough. All they needed to know, he's over 40, he didn't get the job, they hired someone who's 23. That's all he needed to do to get his foot in the door with DFEH, right? Now all of a sudden the employer's on the defensive. We have to prove, no, that's not why we hired her instead of him. We hired her because she was far more qualified. Okay? So that was what we did. We set it up. Here's our defense. We made a decision completely irrespective of age. In fact, all of our paperwork didn't even show the age of the applicants. And so we were able to successfully parry that claim, and the employer came out squeaky clean. So I hope that sort of answers your question. Yeah. But this is why I'm kind of emphasizing the documentation and the preparation part of this, because it will save you in the end if somebody is disgruntled. And oftentimes people are, whether or not there's any merit to their claims. So, kind of covered disparate impact already. I'll move on in the interest of time. So we had a lot I want to kind of get through. So going over some of the main types of discrimination, I mentioned before race discrimination. This basically means treating someone unfavorably with respect to any employment decision because of, and this is kind of an important point here. We're not just talking about a person's actual race, white, black, etc. That is a protected part of this. We're also talking about race discrimination based on association. That's a possible legal claim. Let's say, for example, I were married to a black woman, okay? My employer could not treat me unfavorably, demote me, fire me, because they don't like the fact that I'm married to a black woman. I would actually be able to assert a claim for discrimination by association under race. Same thing with being associated with a race-based organization or group. An example given is the NAACP. If I were to be a member or even an officer of a group like that, my employer would likewise be precluded from taking adverse employment action against me because they don't like the fact that I support that particular race-based group. So you don't necessarily have to belong to a particular category. If you have a clear association with a group or with a significant other, and that's known to your employer, they can't use that information as a basis to take action against you either. Okay. So just some examples of what might constitute acts of racial discrimination or even racial harassment in the workplace. Things like racial slurs, offensive or derogatory remarks about someone's race, display of racially offensive symbols. Anyone think of what those kind of symbols might be? Sometimes we see those in the news recently. Bingo, you nailed it. Confederate flag is probably one of the most frequent sources of complaints in litigation. I won't make any political statements here. This is a legal workshop, but I don't frankly understand why it would ever be necessary to display something like that in the workplace, and an employer tolerating that, particularly if you have an African-American employee who finds it offensive and you don't do anything to correct it, that would likely lead to a racial harassment claim that might have some merit to it. There are some other symbols like that too, but you're already thinking in the right direction. Okay. So what is, oh, I'm sorry, go ahead.
Who decides on what is racially, those symbols that are racially offensive?
What's racially offensive? That's a really good question. When you look at harassment, okay, and we're talking about race, but this covers other forms of prohibited harassment too, like sex harassment, right? What courts are going to look at in terms of deciding, is this considered racial harassment because of an offensive symbol, for example? They're going to look at a couple factors: objective and subjective reasonability, okay? And we'll cover this when we get to the sex harassment in a minute, but it would apply here too. Okay, let's say there was a symbol that someone said, well, that's racially offensive, you're harassing me at work, right? And it's been going on for a long time, so it's pervasive. Okay. Are they subjectively hurt and offended by it? Probably. Okay. Is it objectively reasonable for them to feel that way? Okay. And I say this, and it's important because the law has finally kind of delineated these standards. And they're important to understand. Subjectively unwelcome conduct, including a racially offensive symbol, right? Or in the sex harassment context, sexual contact or propositions, comments, pictures, etc., that someone may find offensive and unwelcome in the workplace. You have to be subjectively upset and offended by it for you to have a legal claim. If you are not offended by it, it's not unwelcome conduct, you do not have a claim, okay? The fact that you maybe don't verbalize it or file a formal complaint about it doesn't necessarily mean it's not unlawful. I like to say that the law protects the timid, okay? Even people who somebody thinks might be okay with something, that doesn't necessarily mean they feel okay about it. They may simply be too intimidated, scared, or simply too timid to advocate for themselves, to file a complaint, to tell somebody, stop, that really bothers me, it makes it very difficult for me to come to work and be productive, okay? They have to subjectively feel it's unwelcome. What's the objective component? The law does not protect the hypersensitive, is the way I analyze this, okay? There are cases, and we'll talk about one in a minute, about the Friends TV show writers, it's interesting. But even if you subjectively feel as though you've been harassed, whether it's based on racially offensive symbols, someone's sexual comments in the workplace, things like that, you may believe that you've been harassed. The law won't necessarily recognize it as such if they determine, examining the situation from the perspective of a reasonable person of the same gender as the victim, or in this case, the same race as the victim. So they're going to analyze it from a reasonable person's standard, from somebody similar to you, in terms of the protected characteristic at issue. Would that reasonable person, hypothetical reasonable person, find it objectively offensive? Even though you personally find it offensive, would a reasonable person agree with you? And in some cases, the answer is no. This person is simply hypersensitive to things that are pretty trivial or typical or mundane, and a reasonable person would not find this to cause a negative impact at work. So I don't know if that answers your question in terms of who decides what symbol is offensive, but that's kind of how anyone, whether an administrative agency or a court, or even an employer conducting an internal complaint investigation, right? That's how those people ought to decide, because that's the legal standard that's been set up to analyze these types of problems, okay? So again, standard for all of these types of workplace harassment, hostile work environment. The legal standard we're looking at is conduct that is so frequent or severe that it creates a hostile or offensive work environment or results in adverse employment action. Okay. Examples of conduct that's not illegal, and this kind of gets to that the law does not protect the hypersensitive standard that I mentioned. Simple teasing, offhand comments, isolated incidents that are not very serious. Okay. That's what I mean. Some people will find an isolated instance of simple offhand comments or teasing. Say, oh my gosh, I've been harassed. This is a hostile work environment. I simply cannot endure any longer. I'm going to file a complaint and then file a lawsuit, and I'd like to get $1 million. Please, thank you very much. There have been cases filed based on one single verbal comment that one person made, let's say a coworker. Okay? That coworker had no ill intent, and they thought it would be funny. Does that matter legally, the intent of the person who's accused of harassment? No, it actually doesn't. Their intent is irrelevant. But let's say they make one comment, and then they stop, and it never happens again. That's not going to be legally considered a hostile work environment. Okay? Cases are really clear on that. It has to be either one of two things, severe or pervasive. And in a couple slides, we'll actually cover the definitions of those things and look at some illustrative examples. But underscores the point, the law does not protect the hypersensitive. That's my own analysis of that. That's not actually a legal case that I'm quoting or anything. That's just the way I look at this thing. So just remember, in terms of harassment stuff, hostile work environment, the law does protect the timid. The law does not protect the hypersensitive. That's a real easy thing to kind of remember, two sides of that coin. All right, I kind of wanted to briefly talk about this thing. Anybody remember this lady from the news recently? Rachel Dolezal, however you pronounce her name? All right, what do you guys remember about her?
Oh, yeah.
So the reason I put this up here as a question mark, is this the future of the way race discrimination and harassment issues may be analyzed in the future? It's just an open question. I just kind of want to throw it out there for food for thought type thing. We already know that California law protects people in the employment context from discrimination and harassment based on transgender status, right? Let's say their gender identity, their internal sense of being either male or female, which doesn't necessarily correspond to their anatomical sex assigned at birth, right? A transgender person. They're clearly protected under California law. That's right in the statute. What about transracial? I heard a few interesting legal commentators talking about this after Rachel Dolezal came out, because no one had ever really conceptualized a person having a deeply felt internal sense of belonging to a race that didn't actually correspond to their, outwardly obvious and visible race. In this case, a woman who apparently is of German and Czech heritage, which her parents confirmed after they were apparently deeply embarrassed by her, let's call it a charade. So she was clearly not African American or black. She was white by every way that we have of measuring and understanding a person's race. However, she, to my knowledge, to this day, has maintained that although she may be white on the outside, she very strongly self-identifies as black. She truly believes that she is a black American. For her, it's not a charade, it's not a ruse, at least that's her story, and she's sticking to it. She believes she is black. So my question, I don't have an answer because this hasn't ever been addressed yet in a legal context, but I'm asking it because I'm predicting that it may someday, and maybe someday soon. Would someone like Rachel Dolezal have a legal claim for racial discrimination based on black race on the grounds that she's transracial? I have no idea, but it's an interesting question, so think about it. Okay, I've actually, I'm going to run short on time, so I'm going to kind of move along. I've covered this case before when I was down here a couple years ago, but it's just an interesting case involving race discrimination in what would be considered the reverse of the traditional type of race discrimination situation. In this case, you had a firefighter's promotional exam in the city of New Haven, Connecticut, and the promotional exam results, had they been applied exactly as the test came out, the only black firefighters in the department would have failed to qualify for promotion, and only white and Hispanic firefighters would have gotten promotions. The city fire department was terribly concerned that they were going to get sued for race discrimination against their black firefighters, right? So what they do, they threw out the test completely, and they found a whole new way to do it to make sure that the black firefighters got included. What happened? The white and Hispanic firefighters filed the lawsuit, which they did not see coming apparently, and they go all the way to the Supreme Court, and they won. It was race discrimination against the white and Hispanic firefighters. There was no legitimate reason to throw out that promotion test other than the fact that they were afraid of a lawsuit. There was no other reason to do it, and it absolutely patently discriminated against white and Hispanic firefighters, and the decision was 100% based on nothing other than the race of the people who passed and didn't pass. It was plain as day, but they got stuck in kind of a rock and a hard place, and they chose the wrong way out, and it cost them. Just interesting reminder that race discrimination protects people of every race, not just what we traditionally consider minority races. White people are protected too, you know, and in California, I believe Hispanic is now the plurality race. They're protected too going forward. Anybody's protected from discrimination based on race. That's an unlawful basis to make employment decisions. That's the one. Okay. Oh, I'm sorry, go ahead.
If the city hadn't taken that step, would the African Americans had a case of, you call it disparate impact?
They would have sued. And
It wasn't intentional, but it was certainly...
They would have lost. They would have sued, and that's what they were afraid of. But what the Supreme Court told them is that they would have lost, because that decision, although it did have, you know, the impact that was favorable to the non-black firefighters and it was unfavorable to them, it did not pass their legal test for disparate impact that rises to the level of unlawful discrimination. It gets a little more complicated in terms of breaking down the legal test for that, but the bottom line was the Supreme Court very clearly articulated that you made the wrong choice here. You should not operate out of fear that your totally legitimate examination for promotion that was purely based on the needs of the fire department, that it just happened to shake out to the advantage of the white and Hispanic firefighters, but it was not any kind of unlawful discrimination until they made it that way by throwing it out. It's kind of a complicated situation, but really I make the point just to remind everybody that you know, white employees are protected too, Hispanic employees are protected too. It's not just African American employees. Sometimes people tend to forget that. Did you have a question?
Yes. Was there a validation study of the test?
I believe that there was, and I believe that the test was completely validated and legitimate.
You want to see the results?
Yeah.
It met their institutional set standards.
Yeah, I mean, they, like I said, the court decided the decision was 100% based on race and nothing else. The implication of that being there was no concern about the test. Okay, the test was valid. It was the race of the people who were qualified for promotion that purely drove their decision-making process on throwing out that test. They had no concerns about the integrity of the test. The test was legit. So they made the wrong choice out of fear. Okay, so moving kind of quickly because I'm going to run out of time. Some other examples, and you can kind of go through the materials on your own. National origin discrimination. This basically covers things like English-only rules in the workplace that are not based on a legitimate business necessity. Foreign accents. Sometimes employers will take adverse action because they don't like someone who speaks with a foreign accent in the workplace, but they don't have a legitimate reason to do it, such as it seriously interferes with job performance. Okay, I won't go through this whole case, I've covered it here before, but it's an interesting case about an employer in Texas who basically told their employees they were not allowed to speak Spanish or any other foreign language at work, even on their lunch break when they weren't on duty. And a couple employees were talking to each other in Spanish on their lunch break, and the employer said, okay, you're fired. Really? Wow. So they filed a complaint with the EEOC. Actually, they filed their EEOC complaint when they found out about the rule. The employer got a copy of the EEOC complaint, fired them within 24 hours is what happened. So they got fired, and EEOC's look, not only is this national origin discrimination, you have no reason to tell people they can't speak in Spanish when they're on their lunch break and they're not even working, they're not interacting with a customer or anything. They're just having lunch and talking. That's ridiculous. They also got nailed for, what else do you think? Retaliation. Thank you. You guys already know this stuff. It's great. The 24 hours after getting a complaint from the EEOC, they kicked these guys to the curb. It's unfathomable to me how this employer ever thought that that was going to be acceptable. Even if they thought their rule was legitimate, how could they possibly think that firing people a day after you get a notice of a complaint is going to cost money? Clearly they got hammered on this one. I think it cost them an awful lot of money. Okay, sex discrimination, we kind of covered this. Basically the same standard that we covered with race discrimination in terms of not just your own sex or gender, but also being affiliated with a particular group, like National Organization for Women is an example. So we covered sexual harassment. Now, I do 2-hour mandatory sexual harassment prevention trainings on this. I know all supervisors, I guess everybody in this room pretty much has gone through one of those AB 1825 trainings. Maybe Mary Beth came down here and did one, I'm not sure, but so those are 2-hour workshops, and it's hard to cover the whole entirety of sexual harassment law within that 2-hour period. So in the waning minutes that I'm finding myself dwindling down to, I'm just going to scratch the surface of this, okay? There's 2 types of recognized unlawful sexual harassment in the workplace. Quid pro quo, which basically means this for that. If you give me a sexual favor or you reciprocate my romantic overture, then I'll give you a promotion. Or the other way, if you don't reciprocate my romantic overture, I'm going to demote or fire you. Okay, that's quid pro quo sexual harassment. It's rarer than hostile work environment, but it still does happen. Hostile work environment, we'll kind of cover it in some of the next slides. So we already talked about the subjective and objective part, right? We're going to hit it again. Hostile work environment sexual harassment, unwelcome sexual conduct that unreasonably interferes with an individual's job performance and creates an intimidating, offensive, or hostile environment, has to be subjectively and objectively offensive or hostile. We've covered those grounds. I won't belabor it, but basically subjective means it was truly unwelcome, not whether it was voluntary. Like I said, what? The law protects who? The timid. Don't be timid, say it. The law protects the timid. The fact that somebody doesn't file an official complaint, the fact that they don't verbally complain, the fact that they don't verbally object to the actual harasser, none of that will preclude them from pursuing a legal claim. You don't have to complain to do it. And the court's not going to consider you saying, well, I think they voluntarily participated. I mentioned this case of Orlando versus Longline. Anybody recognize the name of that case at all? It's from Fresno, a handful of years back. Basically, you had a woman, Janet Orlando, who took a job at Longline. It was a home security system company. Well, they had a motivational sales tactic that they like to use with their sales representatives. They would take alarm, those little lawn signs you get when you get a home security system, ADT or whatever. They would take those signs from their competitors, and to motivate the sales agents, they would have them bend over and they would spank them with the alarm signs. A lot of fun, right? Janet Orlando, being new on the job, she got right in there, she took her spankings and she administered spankings to other agents. She filed $1 million lawsuit for hostile work environment sexual harassment. Employer flabbergasted. She was doing this. She wasn't just laughing when we were spanking her, she was spanking up some of the men. She was a voluntary participant. So how can she now say it was sexual harassment? Well, the jury said she got, I think, $990,000 for saying it was sexual harassment. The fact that she participated and they thought it was voluntary does not mean it's not sexual harassment to her, okay? Subjectively, she didn't like it. What was her testimony in court? They said, oh, you did this, you were a full participant. What do you think she said? I didn't think I had a choice. I was afraid. I was brand new on the job. I was scared to report it. I didn't know what to do. So I just went along with it because I didn't want to lose my job. I needed money. Guess what? That's pretty compelling testimony. And she got a bunch of money out of it. The afterword of that is that she apparently was going around town being very demanding of businesses and telling them, you know who I am, right? I'm the one who got $1 million. So anyway, I'm not sure what that says. Interesting. Okay, we covered the object component. I just wanted to briefly mention this Herbert case. It's really interesting. So what we're looking at again is this reasonable person test. Someone standing basically in the shoes of the alleged victim, and is it objectively reasonable for that person to feel as though this is hostile? And remember, you also have the severe or pervasive standard, right? Like I said, the law does not protect who? The hypersensitive, okay? It either has to be severe if it's one incident or one situation, or pervasive, meaning repeated over time and not merely isolated or sporadic incidents, okay? More than a few, or if it's one incident, it has to be extreme. What does that mean? The court in this Herbert case said egregious conduct akin to a physical assault or a threat of an assault. Briefly, Herbert involved, I think, an 82-year-old woman who was, I think, a secretary at the California Institute of the Arts. She and her granddaughter worked there. And some students put on an exhibit for the school, like their final art project of the semester or something. And the exhibit consisted of a graphite drawing of 82-year-old Mary Herbert, school secretary, and some really lurid sexual activity with men, depicting her naked. I think it said bare-breasted and straddling a man or something like that. I guess they thought it was really interesting artwork. When her granddaughter saw it, she told her grandmother Mary. Mary, I think, had some kind of a panic attack, an asthma attack, went to the hospital. She had all these horrible physical symptoms based on the shock and horror and outrage that would have happened. So they filed a sexual harassment lawsuit. So this is a hostile work environment. Do you think she won her case? I thought that she would too, until she didn't. She actually lost the case. They said it was a single isolated incident. And for one incident to constitute hostile work environment sexual harassment, it has to be severe. What does severe mean? It means a lot more than what happened there. Okay? I was pretty shocked too. That seemed like the kind of case where poor 82-year-old Mary Herbert was going to be a very wealthy woman, and she got buckets. So pretty surprising, but it just goes to show these legal standards are now very well defined and established by the courts in California, and they apply them remarkably consistently and uniformly. So when you learn these standards, you can analyze problems in accordance with these standards, and it helps give you certainty and predictability in terms of the outcomes of these situations, and it can help drive your decision-making process along the way. So it is important, I think, to learn how the courts look at these problems. It helps your thinking process as you encounter these situations too. Okay. In terms of who can be a harasser, and this isn't just specific to sex, but it's kind of from that part of my training. It can be a supervisor, a coworker, or even a non-employee third party. Some people aren't aware of that last part, but there are cases where, let's say, a vendor regularly comes into the workplace, your Dunder Mifflin paper supplier, okay? And whenever Dunder Mifflin's rep brings in the paper, they stare at the breasts of the administrative assistant at the desk, or they pat the rear end of the man who brings the coffee. Either case could actually constitute hostile work environment sexual harassment. Remember, it can be same gender sexual harassment too. That's something people forget. But employers have an obligation to provide a workplace that is safe and free from harassing conduct, even with respect to people who aren't employed by the agency, right? If you've got a third party who comes in and harasses somebody and you find out about it, you actually have a legal responsibility to do something to prevent that from occurring and to remedy the situation. A lot of people forget that. It is the law, and there are cases of it. I mentioned, and I know I'm running short, can there be indirect victims? This one's super interesting. Does anybody think that you can actually sue even if you're not being directly harassed by somebody?
Yes.
100% correct. Absolutely right. There was a case involving a Department of Corrections official, and this is Miller versus Department of Corrections case. Basically, he had affairs with 3 different female employees at the DOC. Some of them were at the same time, according to the facts of the case. And it wasn't those 3 women who sued. They were all perfectly happy with their affairs with the boss. Guess what? They were getting promotions. Well, here's the problem. They were getting promoted way faster than people who had paid their dues and who had earned it. In fact, somebody brand new got a huge promotion over people who had absolutely deserved it, and this woman was completely unqualified for it. It was clear to other women in the workplace who were not being approached by the DOC officer. Presumably he didn't want to have affairs with them, but they were basically being passed over by lesser qualified women because those women were sleeping with qualified. So they filed their lawsuit. The courts all the way through the court of appeals said, no, there's no claim here. They weren't actually harassed. They're just basically, the bystanders. They're the other people around the workplace. And yeah, they feel like they're negatively affected by the way he's favoring these women he's sleeping with. But he's not doing anything directly to them. Goes to the California Supreme Court, they completely flip it on its head and really establish a new way of thinking about these problems. They said not only was this hostile work environment based on sex, because it basically created what they considered a sexually charged work environment, but it was also implied quid pro quo sexual harassment, right? It wasn't, he never told them directly, if you sleep with me, I'll promote you. They clearly got the message by implication of his actions toward lesser qualified women who slept with him and got promoted. That's how you get ahead in this place. In fact, one of the pull-out quote from the case from one of the women who sued, she said, it got to the point where we all looked at each other and said, what do you have to do, F the boss, to get ahead in this place? And the court found that really significant. That's how they subjectively felt, and it was objectively reasonable for them to feel that way about their work environment. Even though the boss never directly communicated any of this to them, they were indirect victims of sexual harassment of both kinds. So it was a really interesting case, and it kind of changed the legal landscape in California in this regard. You are all absolutely correct about that, and that illustrates how exactly that can happen. Okay, trying to move on through some of this stuff. Liability issues, I won't belabor this, but basically sexual harassment cases in particular are really significant. As I mentioned, they tend to be the ones that get into the $7-figure dollar range because there can be personal liability for people who engage in sexual harassment. Employers can be held vicariously liable for sexual harassment committed by their employees. There is strict legal liability for supervisor harassment in California. That means the fact that someone didn't pursue a complaint process, didn't cooperate in a complaint investigation, or we didn't even have notice of it. Let's say we didn't even know that a supervisor was sexually harassing an employee. In California, the employer can still be strictly liable for that if a supervisor committed sexual harassment. Even if we didn't know about it and have an opportunity to fix the problem, okay? All that would give us a possible way to try to mitigate damages. We're still going to be held liable if a supervisor committed sexual harassment.
And then lastly, an important deterrent to anyone engaging in this conduct or tolerating it if you're a supervisor. You generally will not be covered under the California statutes that normally require employees who do things in the course and scope of their employment to get a legal defense paid for by their employer and to be indemnified against any adverse monetary judgments by their employer. Those are the defense and indemnity statutes. Generally, California employees are covered for acts and omissions in the course and scope of employment. Legally, sexual harassment is considered conduct outside the course and scope of employment, even if it happens in the workplace. Little fun fact to pay attention to this. This is really important stuff. Basically, you can get personally sued, and you may be on your own out of pocket. That's the upshot of that. Okay. I know I'm running out of time. I already mentioned this Friends case. I'll let you read this on your own. It's a pretty interesting one. It basically illustrates the point that the law does not protect the hypersensitive, so maybe no on that one. Disability discrimination, these are just more categories. We've already covered the legal standards in terms of what's protected, how they're analyzed. So I'll kind of move through some of these. It does go through an interactive process of determining whether we can provide reasonable accommodations for the disabled. A couple key points I want to hit on there. Number one, question. Do we have an obligation to provide reasonable disability accommodations for job applicants? Everybody sure about that? Absolutely, yes, we do. If a job applicant requests a disability accommodation to assist them in completing the application process, we absolutely have a legal responsibility to engage in that process of seeking an accommodation to help them through the process. That is true, according to the EEOC technical guidance, even if we believe that that person will not be qualified for the job, irrespective of disability issues. If we think they're not going to get the job, we still have to accommodate their disability to assist them in completing the process, okay? There have been cases where an employer decided they don't meet the qualifications anyway. They're not going to get it. They want to complete the process. We help them to see it through, okay? This is just an interesting case that talks about medical marijuana and how, at least at this point, the courts haven't decided that an employer has an obligation to reasonably accommodate a disabled employee's marijuana use. Although somebody decided they were going to take it all the way to the courts to see if they could get an accommodation for marijuana. We don't have to do that as employers. California medical marijuana laws basically give someone a defense to a criminal prosecution. It doesn't actually require the employer to change their anti-drug policies in the workplace. We can still tell employees you are not allowed to use drugs at work, thankfully. California hasn't gone off the deep end completely. Age discrimination is the most interesting part about this, is it protects anyone over age 40, and that now includes yours truly. So I like to remind my supervisor, Mary Beth, all the time, which she thinks is not particularly hilarious, that she better treat me a lot nicer because I'm now in a protected category finally. Religious discrimination, the most interesting part about this is there is, as I mentioned at the outset, a requirement that employees be given religious accommodations in the workplace that are reasonable, just like disability accommodations. Here's the key difference, okay? With disability accommodations, and as you go back through those in your packet, you'll see that our responsibility to accommodate an employee's disability in the workplace, it's a much more stringent standard, and the requirements imposed on the employer are more significant, although not unlimited. You know, we do have certain places where we can say no if it imposes an undue hardship on the employer, if they cannot perform the essential functions of the job with or without a reasonable accommodation, and we don't have to give them their most preferred accommodation for disability, right? We have to find one that's effective in the interactive process. Religious accommodation, it's a much lower bar. We basically only have to make accommodations to workplace policies or conditions for someone's religious practices unless it would pose even more than a de minimis burden on us. So any kind of a significant non-trivial burden would relieve us of the obligation to make a religious accommodation. In other words, it's just a lower legal standard for when we have to actually do a religious accommodation.
Yeah. I'm gonna have to call.
Yeah,
It's
sure.
only because we have
more time.
Well, administrators are committed to other meetings. because
Understood.
We end at 11, but the idea today was to get us,
Actually, pretty much hit it all.
get us pretty closely refreshed with regard to the anti-discrimination and equal opportunity employment information. And we really appreciate that you were able to be here. Yeah, of course. So thank you very much. And remember, if you have follow-up questions, John's available. Our John Branch is a great resource for this. If today's presentation also made you think of some questions that you want to make sure you get answered, submit those to us so that we can follow up and get those answered as well. Anything else for the good of the order today? Yes.
I
Tim?
sent out a email this morning regarding the password enforcement starting December 7th.
December 7th, coming soon, sooner than you think. You're going to have to update your password.
Thank you.
Adjourn. Have a great weekend.